Hello, this is The Grief of Politics, episode 15, and I am Joseph Carlson, and I am joined by Alvin Carroll. Alvin, how you doing?
Did you just call me Alvin?
I think I did, but your name
I
is
am good.
Alvin.
My name is not Alvin.
I was intaking a breath as I was saying your name, so...
Anyone listening, my name is Alvin Carroll.
Yep.
Alvin, not Alvin. There is no L.
Yeah, there's no L.
Doing well. It's a beautiful Sunday up here in Everett. Clouds are coming in, but I'll take the sunshine while I got it.
Yeah, we had some in the morning, and then it came down here, and then it started to rain, and now it's just kind of middle of the road. It's a spring day, so yeah, this is episode 15 of The Grief of Politics. We're going to be talking about the Shadow Docket, the Supreme Court Shadow Docket, but I want to remind you guys, this podcast will hit our website, www.thegriefofpolitics.com on the 20th of the month at 7 a.m. You can go there, leave a comment on what you think of the episode, or, if you have suggestions for what you want us to do, stuff like that. You can find us on Apple iTunes, and now we are on Spotify. I don't have any numbers on Spotify yet because it is in their process. It takes a few days. I have not heard back from them any data, but we're on Spotify now, and you can write to us at gwgpodfellows@gmail.com. Just make sure to drop what episode you're listening to if you have a question about it or a comment, so that way we don't delete it or anything like that. And you can follow me on Twitter at JustLittleJoe, and I will try to promote the episode when it comes out, but I'm terrible at that. But it was my month to pick this month, and I wanted to talk about the Supreme Court Shadow Docket, and something I've been interested in reading about, and more articles have come up about the Shadow Docket. So I did not write a thesis because I think it is an idea kind of growing in my head about where my argument was, and I was thinking about it. I read them, obviously, when I sent them to Evan, but now that I've gone over them again when we sat down to record, I've been thinking a little bit more about them, and I have a better argument for where I want to go, but I didn't write anything. But since it was my turn to present these, Evan, what did you think about reading these articles? Your initial thoughts, stuff like that.
So when we kind of talked about this being our next topic in our last recording, I didn't really know a whole lot about the Shadow Docket, so I was actually kind of curious to do this and learn more. The thing is, I don't really feel like I still really fully understand what the Shadow Docket is, because even reading through the article, some of it seemed to sort of contradict. I do have a better understanding. I definitely understand why it is a concerning thing, but still don't have a complete, total understanding. Several of the articles that you chose have some pretty heavy legal jargon.
There was a couple that I chose, but they were like USA Today or somebody commenting on it. I know the one was very legal, but it is from the Bar Association, so I thought for them to write about it, there is some legal jargon there, but they would probably be the most balanced, and they didn't bring people from both sides about this isn't a new thing, this is a new thing. They kind of, and I figured, in a way, unless it's the Supreme Court writing about the Shadow Docket, I figured the Bar Association was a close enough, in the window of the horse's mouth, as it were, for how this is, what's happening.
I mean, they are all lawyers, so they would have a better understanding of the legal practice of using the Shadow Docket Supreme Court.
Yeah. I mean, for me, it was the same way. It was hearing things and reading things on the peripheral, but then once you start reading it, and I think where my argument is going in this is that the fact that one of the justices, I think Alito, I don't think it was in this article, another one said that this isn't new, it isn't, he doesn't like the term Shadow Docket because these are more emergency measures, so it's either a stay or a refusal of something that comes from a lower court, like an emergency, right?
Yep.
But what my argument is, and from reading this, is Bush and Obama had between them about 8 emergency dockets or shadow dockets. The Trump administration had like 40, like an insane number of shadow dockets, meaning during that time there was less transparency because, again, the justices can have 1 or 2 lines to dissent or agree. They don't have to sign their name, and some of them don't have to. They do not have to explain why they came up with what they did. They don't have to listen to oral arguments, from what I understand. They're basically just sit there, read the case that's come from the lower courts, and make a decision. And what a lot of people are saying is the uptick of that is worrisome. But anything else to add to that before we get into the first article? Or
I mean, I would basically concur. I'm not a fan of using legal loopholes to accomplish legislation or to achieve a political end. Admitting, the shadow docket is exactly like you said. It's meant it's a procedural thing meant for emergencies, where whatever that law may be would have major impact on one of the parties, and so they're wanting to prevent the law from moving forward or stopping the decision from moving forward until after the case has truly been heard. And usually that's the intention. They want to actually hear it all the way through. Historically. Mm-hmm. With the way it's being used now, it's kind of like, oh, yep, Supreme Court made a decision. But one of the things they talk about in here, too, is because there is no written decision and dissension and justification and reasoning for the law, it's very difficult for lower courts to use this as precedence in the courtroom.
Because that's what it is. It's a stay or a refusal from a lower court. They kick their decision down to a lower court, and the lower court has to read it and decide like a states' right thing. Like, okay, this is how this applies to our state in this situation. And they do bring up an example we'll read later, but one of the lower courts, like, I don't know what to do with this. Like, this is so vague. I don't know how to apply this to the situation that we're in, basically.
Which, in and of itself, is a part of the issue with using the shadow docket. I did also look up the numbers in this article you were talking about. It's between 2001 and 2017. There were 8 emergency applications through what we're now referring to as the shadow docket, or was become commonly known as the shadow docket.
The emergency docket, yeah.
And during the Trump administration, there were 41 such applications.
Yeah. Which some people would
go ahead.
But some people would point to the fact that because there is a conservative slant to the court, that they're leaning more heavily on the shadow docket, and that bothers some people. Now, if that's true or not, I don't know, but because it is the shadow docket, like you just said, and they don't have to write whether they agree or disagree, you don't know. But it seems like there has been, in that article, they write that most of the liberal judges have been very vocal about, we need to stop doing this. We need to not use this, this process.
At least not the way it's being used. And the thing is, Donald Trump is extremely well known for manipulating the legal system to his advantage. He's always done it, be it procedural application of it or technicalities in the application of it, which his administration was very good at. And a lot of things that Donald Trump pushed forward were challenged. And a lot of things that were challenged in such a way that it was actually liberal politicians, left-leaning politicians, that were the ones bringing the challenges to the Supreme Court.
Right.
And as we are well aware, a lot of appointed judges from Trump's perspective have blocked things that he's wanted to do. It kind of reminds me of like Donald Trump as the older version of Anakin in Attack of the Clones, where like he's talking to Padme and she's like, well, what do you propose? Well, someone should just make a decision. Well, that sounds a lot like a dictatorship. Like it's kind of what Donald Trump feels like. Like, I'm just gonna do it.
I think that there's a lot of stuff, obviously, that he wanted to do that a lot of people pointed out, I mean, without totally derailing conversation, but like the election, everything that happened, there was a lot of guardrails in place to make it hard to do what he wanted to do. Mm-hmm. And, thankfully they were there. Well, I mean, before we get too far, I'll read...
let's go through this ABA article.
The first one was the ABA one. And I'll just read the first couple sentences. This is by the American Bar Association. I think does this have a date? April 14, 2021. And it's just called The Supreme Court Shadow Docket is under review by the U.S. House of Representatives, which I thought it was amazing that the House is like, ooh, we should look into this. This term was first coined in 2015 by law professor William Bod. The term shadow docket refers to the thousands of decisions the Supreme Court hands down each term that defy its normal procedural regularity. Unlike the 60 to 70 cases the justices hear on the merits document, where the court receives full briefings, hears oral arguments, and delivers lengthy signed opinions, cases decided by the way of the shadow docket lack such public deliberation and transparency. According to the court watchers and analysis, increasingly often in recent years, the justices are handing down 1 or 2 sentence summary decisions late at night in controversial cases like those involving the recent federal executions. These shadow docket orders often do not include information about how each justice voted or why the majority came to a certain conclusion, potentially lowering or leaving lower courts in the dark about how to apply Supreme Court precedent moving forward. That was a big sentence, but basically that's the ball game for the shadow docket. The fact that they can do this late at night. There's one we'll read later about specifically about Brett Kavanaugh, and there's one we'll read about the other side about what they thought about. But hearing that, at least, or reading this article, what? So you said you wanted to learn more about the shadow docket. You didn't know much about it. I mean, there is legal jargon in here. Was it at least informative? This article?
Oh yeah, it's just very heavy with the legal jargon, of which I am not a lawyer or an attorney. I don't use a lot of this language commonly, so it's like you had to look up certain words, not anything you just talked about here, but later on in some of the articles. Learned a lot. I mean, again, this was extremely informative for me. I really still don't feel like I have a true grip or in-depth understanding of exactly what the shadow docket truly is. Because, like I said, there's some contradictory aspects of it. This article, I think, touches on a little bit where the justices of the Supreme Court make a decision. It's difficult for lower courts to use it because they're putting out these super summary descriptions. There's no real in-depth analysis that's coming out from the judges specifically, except for, like you said, when they're dissenting. I can't remember the name at the moment, but one of the justices has come out multiple times and been like, hey, this is terrible. We shouldn't be doing this. But it's also, it's put in place for a reason. And I really, in this article, I appreciate actually, like you said, that Congress is getting involved in taking a look at, what's going on here and should we limit it? Now, there's some challenge to that, right? Because it's the Supreme Court. It's a separate section of the division of powers in our government, how it's set up.
Right. Yeah.
So there's a little bit of how much influence do we want Congress to have over the Supreme Court? But on the flip side, the purpose of the Supreme Court is to decide these ultimate cases, at the highest level, to make a decision, to develop precedents so that the rest of the states can understand the interpretation of the Constitution and apply it to their law. If we aren't doing that, then what's the point of it? I mean, ultimately, the Supreme Court should basically be saying, no, we're not going to hear this case, as opposed to making some form of summary decision.
Right.
Flip side, again, in Donald Trump's administration, he did a lot of executive orders. He pressed through a lot of legislation that really rubbed Democrats and liberal politicians and Americans the wrong way, and so there was a ton of lawsuits that were brought up, and multiple things that Trump pushed through were blocked via the shadow docket. So this isn't a conservative, this isn't a liberal thing. With the ultra-conservative Supreme Court, yeah, they're more likely to make decisions in that direction, but both sides use it. And
yeah, I mean, they do, but I like to go to my argument in the beginning. I think what's happening and what people are bringing up is the fact that it seems to be happening more and more lately, which may be in correlation to there's more conservative justices on the bench now. And so since we don't know who's signing it, or it sounds like they can if they want to, they don't have to. So if they don't have to, then some of them don't. So there's very little transparency. It seems like in a normal merits document, they would say, Justice Alito thought this way. Justice Thomas thought this way, whatever. So
there's advantages and disadvantages to that, right? Like, that allows someone who is politically aligned, left or right, to make a decision where they're not going to get called into question, which is somewhat nice, right? Like a blind ballot when doing voting for like union votes or something. When it's an open ballot, like I'm not going to vote my opinion because I've got all that social pressure.
Right.
And it's not a true representation of views and opinions. So there's back and forth on it. I think the original application and purpose for this is a good thing. I think the overuse of it is it's weighing down the Supreme Court. I mean, they talk about, I think in the next article when we go into it, they talk about Supreme Court's caseload over the last 2 years or 3 years has gone down. Oh. So they normally would do 60 or 70 cases. The last couple of years, they've done like 50.
Well, they do
55.
merit. They do 60 or 70 merit cases.
Yeah.
So, with I guess the Shadow Docket, since they're faster, I guess it allows them to come to more decisions. Is what I'm understanding. I guess that's how I understand it.
So it was very interesting. Like, they do a really good job in this particular article of really breaking down, like, both politicians on the left and the right are concerned because it sets a precedence for politicians on the left and the right to utilize this.
Right.
With a conservative majority Supreme Court, there is a viewpoint that they are more apt to make decisions in benefit of the conservative side of the argument in cases, but that hasn't necessarily proven completely true over the last 3-4 years.
The next article we read may
and then the third article goes into like how it's gone the other way around. Like, it's both sides are using it, and it's a bad precedent, right? Like, we're removing transparency from the operation of government, which is something all of us want. It's a really interesting thing. So I don't know if we want to move into the next one where we go into kind of the specifics, because there's great examples here.
Yeah, I mean, I think we will, because I think this gives a concrete example. So, like, this was written by Slate. It came out on February 2022 by Steve Vladeck. I hope I'm saying his name right. It's called Brett Kavanaugh's Defense of the Shadow Docket is Alarming. And I'll just read the opening paragraph. On Monday, by a 5-4 vote, the Supreme Court reinstated the proposed congressional district maps in Alabama that 2 different lower courts had held diluted the power of black voters in violating the Voting Rights Act. The ruling is temporary. The justices agreed to take up Alabama's appeal of the lower courts in their October 2022 term. But as election law scholar Rick Hansen has noted, Monday's decision has both immediate short and long-term effects. Alabama's racially gerrymandered maps will now be used at least through 2022 midterms, and the justices have made it harder for any plaintiffs to bring Voter Rights Act challenges to congressional redistricting. Let's see right here. They basically, right here. So this kind of says, this is kind of the crux of why this is not good. Yesterday, the Supreme Court was asked to decide whether to issue a stay of the 2 lower court rulings in the Alabama case, while Alabama appealed them, move that have prevented the lower court's decision from going into effect. The lower courts had blocked Alabama's maps on the ground that the state had willfully refused to create a secondary majority black congressional district, instead divvying up black neighborhoods to inflate white residents' voting power. Stays is supposed to be extraordinary remedy meant for extraordinary cases where 3 different things are true. First, the party seeking a stay must be likely to win their appeal. Second, it must be that the case that's not freezing the lower court's ruling while it is appealed would cause the appealing party irreparable harm, that is, harm that a successful appeal cannot adequately remedy. And third, the public interest to both the parties and society at large must be served by such relief. What this test hopefully drives home is that the stays are supposed to be rarely granted and are supposed to be limited to cases where lower courts didn't just err, but erred in ways that cause immediate harmful effects to the party. And
which is the case for all stays, right? Like, whenever a stay is applied, like, that's the whole thing, is while waiting for the appeal to go through, harm that is done is irreparable. Right. And in this case, I mean, it definitely is irreparable. And in this particular case, it's been pretty well publicized because this stay will have a direct impact on the voting in Alabama.
Yeah. And this isn't the first state. I think it happened in Pennsylvania as well. And I think There was one other state. Anyway, so what they get into this article, it says, we can't know how a majority of the justices applied these factors to the Alabama cases. Only Justice Brett Kavanaugh, joined by Justice Samuel Alito, wrote to explain his rationale. But what he wrote was not exactly reassuring. First, Kavanaugh suggested that the normal rules for stays don't apply because these are election cases, and election cases are covered by a different rule known as the Purcell Principle. Also articulated on the Shadow Document, the federal courts cannot block election rules on the eve of elections. Thus, to Kavanaugh, the burden was on the plaintiffs to show that the underlying merits are entirely clear-cut in their favor in order to win in the district court, and by his reasoning, the fact that there is even some question on the merits of the case justifies his freezing the district court's rulings. But there's one critical problem with this line of thinking. The election in Alabama is still 9 months away. Even the primaries are in late May. It's hard to see how district court rulings in January even implicated that contestable principle unless the court has silently expanded it to swallow all electrification.
And Lisa and I actually had a conversation about this too after I read this article, and it's kind of mirrored the same way. Like, how far away from an election is too close? Like, at what point is it too close where it's going to have an immediate impact?
I mean, and what some
can't feel it.
Yeah, and what some people are saying is like 9 months is kind of a long time. You know, like if it's 3 days, sorry, man, this has got to be what it is. But you know, what is an eve? I would say that 9 months is far enough down the road that you could do something about this, and then have basically have the law go through or whatever. So,
yep. So continuing on is the next section of Kavanaugh's description or response.
Oh.
In the next paragraph.
Oh, the second, perhaps, this one?
Yeah.
Yeah, second, perhaps recognizing how weak the election specific argument is, Kavanaugh also attempted to suggest that Alabama would be entitled to stays of the lower court ruling, even under the court's extraordinary three-part standard. In a footnote, he wrote, even under the ordinary stay standard outside the election context, the state has at least a fair prospect of success on appeal, as do the plaintiffs for that matter. This sentence gives up the game. If both sides are equally likely to prevail on the merits, if it's a 50-50 case, then the only justification for a stay would be if every other factor is decisively favored Alabama. And yet, not only did Kavanaugh have nothing to say about the other considerations, but there are compelling arguments that they, too, would favor leaving the district court rulings intact. Alabama still has plenty of time to adopt district maps that don't violate the Voting Rights Act, so any harm is not irreparable, and presumably it is because it is a public interest, and especially the interest of Alabama's 1.3 million black residents, to have representation that does not unlawfully dilute the power of black voters.
Mm-hmm.
And I want to read this. I'm reading most of this article, but there's a great thing right here. It says, instead, what's really going on in this case is made crystal clear by Chief Justice John Roberts' technically but analytically devastating dissent. Roberts' short opinion expressed sympathy for Alabama's claims on the merits, but also stressed the fundamental problem with the court's use of the shadow docket. That ruling for Alabama will require the court to make a new law because the district court properly applied existing law in the extensive opinion with no apparent errors for our correction. In other words, Roberts voted against staying the lower court's ruling because they were correct under the law as it exists today, even if he's perfectly willing to change those laws tomorrow. Against the backdrop, it becomes clear why the ultra-conservative majority came out the other way, not because the justices disagree with Roberts that the district courts were right, but because they're willing to change the law today. And they talk about, it will be harder, they basically have a timeline of like when they can change it and all that kind of.
Mm-hmm.
And Justice Elena Kagan was entirely correct in her dissent to complain that the ruling is one more disconcerting long line of cases in which the court uses its shadow docket to signal or make changes in the law without anything approaching full briefing and argument. And that's kind of what we're talking about.
Yep. And going back to the second point with Kavanaugh, I would point out that he couldn't, in this particular decision, discuss either side of it. Like, there'd be legal implications and ramifications if he were to come out and, like, argue the case publicly and why he made the decision. Like, he said what he could legally say. However, he also gutted his own argument by saying both sides have an equal chance of winning, because it's true. Like, the rules aren't being applied correctly.
Yeah, he's applying them to one and not the other.
I also greatly appreciate Roberts was the one to dissent here, because when Roberts came in as a conservative justice appointed by Bush, everyone was freaking out that he was going to be the Chief Justice because he's conservative, and yet he's probably the most frequent justice to flip sides. He will make decisions on both sides.
More of a centrist then, as opposed to yeah. I mean, this is the problem that I see, and this wasn't the first article about the Shadow Docket that I read, but the fact that, hey, they don't have to put their name on this, and these things are just going out into the world, you know? And
at the end of the day, how often do we actually even find out if they even meet the standards to be a part of this emergency decision process, right? Like, they're supposed to be super few and far between, and they just aren't. Now, again, I think part of it is there's been an emboldening of lawyers to bring these extra cases to the Supreme Court, but also the Supreme Court is willing to sit down and make these decisions on cases this way too.
Yeah.
So it's interesting. Again, I think all sides are correct. Like, this needs to be reined in because it just gets abused.
Yeah, I think the last article. Oh no, did I close it? I might have just closed the. Oh, it's right here. It's Much Ado About. It's called. It's the Center for Immigration Studies. It says when was this published? I don't. Oh, September 7, 2021, by Andrew R. Arthur. It's called the SCOTUS's Shadow Docket is Much Ado About Nothing, by those who should know better, and basically. They started the article by saying the New York Times ran a piece recently captioning the Texas abortion case highlights concern over the Supreme Court Shadow Docket. And he basically goes over what we already went over. But he basically said this thing happened with immigration, and the left said nothing about it. Mm-hmm. So they had a problem when it came to voters' rights, but not when it came to immigration.
Correct.
And that's basically what the whole article is like, well, if we're talking about both sides using the law equally,
Yep.
You should be upset. And I agree with him that there should be problems, that we should talk about this. But again, going to my argument in the beginning, because of the uptick of what has happened, now we really need to start looking at it. You know what I mean? Like, that's what I feel. I mean, reading this, so.
Yeah, I mean, how many people were aware of this until the last couple of years, right?
Yeah, and again,
we've been hearing about, during the Trump administration, we kept hearing about all these different things that were contested and having them go up to the Supreme Court, and then the Supreme Court doing this stuff, but we never really understood, one, the volume. At least I didn't. Like, I don't record and track this stuff. It's just specific cases get discussed.
Well, lucky for you and I, someone did, so we were able to do the episode about the Shadow.
There's 41 cases decided this way or brought to the Supreme Court this way during the Trump administration. So there's 41 there, and we've maybe heard of 2 or 3 of them. So what are the other 38?
Right.
What are the ramifications of those other 38? I mean, as we've already said, they're not permanent, right? Like, I even sort of disagree with Roberts here when he talked about they want to make new law, because they're not setting precedents when they make a decision this way. Like, they're just putting a stay or allowing through a lower court's existing decision.
Yeah, I didn't understand that argument, but again, I'm not a lawyer. Maybe he's saying I don't know.
If they were to actually try it or go through the trial process and hear all of the arguments and then make a decision, they would be creating a new precedence of law. Is basically what he's getting at. Because the law as it stands was followed by the lower court, was Roberts' argument, which I would agree with. I mean, in that particular case, kind of going off the track a little bit, gerrymandering is a terrible, awful thing. All across the country. I don't care if you're in a Democratic state or Republican state, the party in control does it. every single time because they want to stay in power. And it is a horrible abuse of our democratic system that strips power from the people in order to keep those in power in power.
I think there is some movement on making gerrymandering, well, like these cases, but making it flat out. And I think they have to do it on the state level.
Mm-hmm.
Say in this state it's illegal to gerrymander or whatever. You just
I mean, you could pass it as a federal law.
Right.
And that would be how it would happen. States would get sued. It would get appealed up to the Supreme Court. The Supreme Court would review it and then say, no, this isn't legal. And then at that point, Supreme Court has set new precedents, thus creating new law. All the other states would have to follow.
Right.
And there's always discussion of getting rid of gerrymandering. It happens all the time. No one likes it, and yet nothing ever happens because we, as voters, don't hold our politicians accountable.
Well, also, I mean, we probably should do probably an episode on gerrymandering because I've been reading about it more and more, and it's something that obviously comes up during voting, but I think is getting more and more egregious. And it's not just Republicans, but they are, I from what I've read, are more disposed to do that. Then, not to say that Democrats have done it, but it seems lately
probably because you read more left-leaning publications. Both parties do it.
Yeah,
I know you are pretty well mixed, so you're getting like more than just one side of the argument. But I know you still lean in that direction, and
right.
So it's easier to see the offense of the enemy as opposed to accepting your team's offense.
Well, what I might do is go to like the bar association or somebody like that because they have to do those. And if they say like, no, these are the people that do this, then it would be proved like they're just in it legally. They're going to do a case or whatever. They don't, lawyers vote different ways.
I can practically guarantee you Washington State is heavily gerrymandered in favor of Democrats.
I mean, probably, but it also has to do with population density on this side of the mountains, I would imagine,
Well, yeah, but that's how the whole voting districts comes about, right? It's like you're supposed to be splitting it up so there's equal representation and how that all happens. And so some districts are really big geographically, some districts are really small geographically.
And then like the Electoral College, like I know some states do with the Electoral College where it's how, so like you have 10 electoral votes, let's say to make it easy because I'm not a math major, and then 60% of the popular vote goes to the Democrats. That means only 6 electoral votes would go to the Democratic candidate, and the other 4 would go to the Republican candidate. So, like, that would be a good way to whatever I just said. Basically, it's the idea that the popular vote determines the percentage that goes to that candidate. So
that's something that's been proposed, but is not the case.
Well, in some states they do that though. Like there is states, like 2 states that do that. Where if you look at the map,
I think that has to do the difference between primaries and caucusing. I might be wrong on it.
Well, I have seen it. I know during the presidency there was like 2 states, like Rhode Island and whoever. There was 2 states. It was like split, and they were like this went to this, and I was like, that's an interesting way to do it. So now, people could say, if everything's equal in your state, I mean, electoral votes are one thing, but like you'd give a little bit more power to the people than the all or nothing thing, which a lot of people have problems with the all or nothing electoral college system. So.
Yep. But if you balance it on the popular vote decides what percentage of the votes go, then you might as well just get rid of it.
Yep. No, I mean, yeah, sure, we can talk about that too. I think it's terrible. It's terrible that some states, I mean, hence the term flyover states. Anyway, getting back to the Shadow Docket, that was my only argument in the beginning is this is a worrying trend because it seems to be happening more. And like you said, there was 40 cases. We've only heard about 3 of them. So we don't know. We don't know what's happening.
I mean, I'm sure we could look it up. But people have to dig into it and be willing to do that research. And how many people want to sit around and research what court cases have been decided or are being decided on the Shadow Docket? Yeah,
I mean, even researching this, trying to find ones that, the Bar Association was the one that I was like, ugh, but it is by the Bar Association and it
access and where to go and where to look it up. Like if you have
right.
I have a friend that's a law student. I might be able to reach out to him and maybe revisit this at some point if we wanted to go into that depth. But like the regular resources that we go into to look this kind of thing up,
no idea. Yeah,
super hard.
No idea.
Like there are resources. I follow a YouTuber who does a lot of stuff on investing, and so a lot of his videos are on court decisions and presidential statements and worldwide things that impact stock markets and trading and cryptos and real estate, because he talks about kind of all of those things from an investing perspective. And oh crap, where was I going with that? Had something to do specifically with.
Well, he probably
he found a resource during COVID that he paid for annually. I think it's like $500 a year or something, that gives you access to research papers, like all kinds of research papers that have been published. And so he was going in and reading that stuff. And he's like, I know most of you won't do it, but for those of you that want to, like, here's this resource. You can pay this money and you get access to all these papers. So I'm sure there's something similar probably for law.
There's got to be like a Supreme Court newsletter of like, here's what's on the docket, here's what happened here, this was the Shadow Docket, this was the merits docket, you know, like stuff like that. And you'd be like, whoa, wait, back up to the other thing. So, I mean, that would be, I think, interesting. So, I don't know. I mean, I'm not going to say this is I kind of did, but I didn't really mean it. It seems like this is happening more with conservative justices, but because there's no transparency, that is what I've been led to believe. You know what I mean? Because, but if they
we've had a more conservative slanted Supreme Court for the last couple of years, right? Trump got Kavanaugh and
Barrett.
Coney Barrett.
And you got Gorst in the beginning.
And
Neil Gorsuch. You got 3. That's didn't they say that's like has only happened like once or twice? Like that doesn't happen, especially in a one-term president that gets that many justices, you know?
Yep. And so, of course, through Trump's presidency, we get a more and more conservative Supreme Court.
That's one thing I don't like. I don't like the statements you hear from conservatives about, do you think packing the court is good? I'm like, you guys did it, kind of. Like, you kind of did.
No, because the term packing the court is building a larger court to add more.
No, I know, but I mean,
justice.
they did some of that. So
they didn't expand the court. People retired and died, and they assigned justices as is their right.
Wait a minute. So Ruth Bader Ginsburg died. I remember
she retired very shortly before.
Right, and then passed. But then...
And then she died.
How did... I forget about how Gorsuch came. Did somebody retire? That's what I forget now.
Yep. I just don't remember who it was.
And then... isn't there... Yeah, the... What's his name? There's one guy who's very old that people want to retire. He's retiring. And now Biden has a Supreme Court pick.
And there are... was it Alito that waited until there was a Republican in office so that he would be replaced by another conservative? Maybe it's someone else that did.
Probably. Yeah, I don't know. All I'm saying, I think, with this is, I think you and I agree that there should be more transparency, and the fact that there isn't is worrisome. You know, but now the House...
to meet the purpose of the Supreme Court, there should be, right?
Yeah.
Like these kinds of things sort of happening, you know, they allude to it that it's happening in the middle of the night and not being discussed in the news cycles. But I think even if it happened in the middle of the flipping day, the news wouldn't pay attention to it.
Or you know, you always, like, for legal purposes, imagine being a law student and not being able to read about these cases. Right. So you don't know how they, like, so instead of literally being in class debating it with other law students and your teacher and building a case, and if you definitely disagree with it, at the end of the argument, you'd be like, oh, you won me over. You know, I see the logistical, you know, I see the steps they took. I'm reading the decision. I'm reading the dissent. It's kind of all swirling around. I really thought about it last night. Yep. And they all had to sign their name on it. And they all wrote a whatever page decision. I wrote it. I really stick with so-and-so saying this, and that really stuck with me. And now you're just like, well, 3 out of 4 of them decided to write something in dissent. Or not 3 out of 4. 3 out of the 9 decided to write something, so we really don't know. So what do these other justices think? Oh, we don't really... There's no idea, so how can we debate it, you know? So there's nowhere to go, in a way, you know, intellectually with that debate.
And I mean, part of thinking through these articles and kind of this process, I sort of had this mini epiphany that 100% makes sense when you think about it, but isn't something that you would usually think about, a normal person's going to process. the Supreme Court's kind of always done this anyway when they decide not to hear a case. Because when a case is brought to them and they feel that the law was applied correctly by the lower court and they just refuse to hear it, they've basically applied or created precedents for that type of a case.
That's interesting. I didn't think about that. You're probably right. I mean, you're right.
But that's public. We're refusing to hear this case.
Yeah. You hear a press release or something saying they won't hear this, or we can't hear it now. We will hear it in the next term, whenever their next. We can't hear it till 2023. Our docket right now is full for 2022. We're going to hear that in January of 2023, whenever their term is, whatever. I don't know their terms of when they're in session or whatever.
That gives me another idea too, though, on the concept of packing the court. It is interesting the Supreme Court is hearing more and more and more cases. They're not able to get to as many cases, right? They normally do 60 or 70. There's only the 9 justices, so they can only hear so much. They can only make so many decisions. I wonder if it would be, instead of putting more justices on the court, if it would be more appropriate to create like Supreme Court 1 and Supreme Court 2.
Well, I think it would have to do something where, maybe, or it would be something where we would have to have more justices or more judges at the lower level. You know what I mean? Like so that way they can filter stuff before it gets to the Supreme Court. I
mean, that's the way the court system is set up again. Anyway, like the district courts as they go up.
Yeah.
That's how it's supposed to work. You start in the local court, you work your way up through the system. They're supposed to sort of filter out as the decisions become more and more firm, and people are kind of stuck with those decisions.
Well, I think one of the... Well, like I said, I think one of the things is I would like to see... I guess this would be another topic, but like, is there vacancies at those lower levels? Do they need to be filled? Is that part of the problem? Is this a systemic thing where it's going up because there's not... enough,
there was a ton of justices that weren't in, and that was a big thing that Trump did when he got into office. Was he went on a appointing spree and appointing judges, and then humorously, all those judges became traitors and didn't support him when the election was quote stolen. By the way, I don't think it was. I am not endorsing that idea. I think our election system worked exactly as it is supposed to work.
Well, also when Giuliani and those people, you could read those decisions. I mean, they were published in every news thing of like they would go up there and they're like, what evidence do you have? And they're like, we didn't bring any with us. And they're like, I think that Michigan judge really ripped into him too, where he was like, you're wasting the court's time. If you're going to come to us, you need to come to us with something. And like you could be disbarred for this basically, like coming to the court with nothing, And so it's one of those things where, and everybody pointed out like, hey, this guy was appointed by Trump. He's literally just reading the law going, there's no, probable cause for this, So, like I told a lot of my friends, conservative, or like, if there's something there, somebody will find something and it will move forward. But the fact that there were so many cases and so many, just stamping down of like, stop. It's a long shot's one thing, and that was just a totally other thing. But anyway, I mean, getting back to the Shadow Docket, again, I don't want to be negative, but I think it is something that I hope you and me are looking at it now, and now we're able to pay more attention to it, or at least read it, or know a little bit about what it is. And some of that, I don't want this podcast, obviously, we've been friends for a long time. We don't really attack each other. If we disagree with people, or with each other, we disagree. But the past couple ones we've done, the weed one and this one have been actually more informative than argumentative, to the fact that, like, it's like, I didn't know what this was until, this happened. So, wow. So, yeah. I don't know. Do you have any closing thoughts? I think I kind of said my piece. I don't think...
I mean, both of us have kind of said the same thing, right? Like, this is something that most of us aren't aware of. I think it's something that most of us need to be aware of. Right. I would like to say that I will pay more attention to Congress kind of having the discussion about whether or not the Supreme Court should be having these types of decisions.
I'll send you those articles late at night like I normally do. Like, hey, check this out.
The process of hearing, like, stays reviewing those kinds of cases shouldn't go away. And they don't need massive amounts of justification. Like, they just don't. Like, now we're going to stay the lower court's case. They did not apply the law correctly. And we have to hear this case. So until we can hear this case, we're going to stay it.
Yeah, I mean, too, oral arguments are powerful. That's why we have a court system where you can stand up in front of somebody and goes, I've read these precedent or these cases. This is why I believe this is illegal or legal or whatever. And for the justices to hear that and interpret it differently and actually have, like, I'd like to know a little bit more about the deliberation process. How long does it take to deliver these things? How much do they talk? They obviously talk to each other in their chambers. Like, how does that work? You know, like, in the fact that they don't have to have that for the shadow docket, that's troubling too. Where they just kind of read, I mean, and they're used to reading legal documents, but there's kind of a removal of empathy or any kind of that when you're just reading it on the page, as opposed to somebody saying, no, this affected, you know.
It's very difficult to remove slant from an article like that, though. Even when you're talking about facts, unless you're like stating facts in a bullet point format, for the most part, it's extremely difficult to remove points. When I was working at my former IT company, one of our clients was a company called USA Facts, USAFACTS.org. Nice. And what USA Facts does, the whole mission is to take government data and statistics and strip all of the bias from it and publish it as raw data without political bias, so that news agencies, universities,
they can just pull stats for stories, basically.
Can use the statistics without it having a slant, and then make their own decisions from there with that data. USA Facts is owned by Steve Ballmer, and it's kind of his baby. He really wants it to be as non-biased as possible. I witnessed him talking to some of the people that work on the page, and he's extremely passionate about making sure that not to have bias go out in their publications.
That's interesting. I'll have to check that out. What is it? I'm going to write it down. What is that called again?
USAFacts.org.
Hang on.
Now, admitting people on the team have their own political bias and slant, but they really work hard to keep as much of that out of what goes out to the webpage, out of the publication.
Oh. No, that's good to know. I'll check them out. I'm just erasing the subjects we talked about. So we know. So, yeah. I mean, I think we kind of agree. We want more transparency, I think.
Different reasoning.
Yeah.
I mean, you definitely think it has to do because there's more conservative judges on the panel, and me personally, I think that both sides are abusing this, and all that happened is during the Trump administration, people were like, oh, we can use this way. We never thought to use it this way.
Right. Yeah. Well, yeah, that's another episode. That's a totally other. I was like going to say something. But it is your turn to pick next episode. So have you chosen the topic that we will be talking about next episode?
To be honest, I haven't even thought about what topic to go into next.
Well,
I think
how about this? I got a list of ones that we've talked about.
Okay.
We can see if any of these hit your fancy. So we got voter rights, domestic terrorism, healthcare. You being a libertarian. No, I just wrote libertarian.
I thought
and
we had already talked about healthcare.
We talked about, I think what we talked about was like abortion and things like that when it came to healthcare.
It's true.
We did not really talk about the state of healthcare. And I actually would like to talk to you about healthcare because, yeah, man, it's a humdinger of a thing. So
yeah, well, that's definitely one where we're going to have very different opinions.
Yeah, do you want to do that? I'm not forcing you. It's your choice. But I've read, these are the things you and I have talked about on the phone. I tried to keep a ledger because we always forget when we have hour-long conversations on the phone about what we're going to talk about. I was thinking
we should go into gerrymandering because both of us were really talking about that. But I think gerrymandering would be sort of like this episode where it's going to be more of an educational, we're learning things outside of what we're used to talking about. So yeah, let's do healthcare.
All right.
And we can do universal healthcare versus privatized healthcare. I know we've discussed it in bits and pieces, but we can dig into it more in depth.
Yeah, I think it will be interesting because there would be some things I'd want to pull. I know you're supposed to be supplying the articles, but there'd probably be an article I would try to find, not to like derail our argument, just another thing. So,
yeah.
So we can do healthcare. All right.
I have personal lived experience with different health systems just through being married to Lisa and how different countries use healthcare. Structure healthcare. Because Lisa grew up in Japan.
So she's still kind of blown away sometimes when she's in the States. Like, what? Yeah.
Oh, yeah.
There's a YouTuber group I follow. I've talked about before. Kind of funny. One of the co-founders had a baby. His wife is Canadian. She's obviously living in the States. She's an American citizen now. He said that's not as easy as you think it would be, but now she's an American citizen. They had a child, and he was like, man, what happened to our credit card? And it was like their weekly chat show when they just chat about stuff. And he's like, sorry, I was checking my credit card bill. It is insane, and it's from our kid. These are all hospital bills. And he goes, does this blow you away? And she was on the call with them, the Zoom calls. You could see her in the back, and she goes, no, this is all really weird because I'm Canadian, and we don't look at medical bills, this is weird that like our credit card's being drained because we had a baby,
Yeah.
So next month we will be talking about healthcare, and you will be providing articles. Avin, is there anything you want to plug before we leave?
As always, I'd like to plug my kind of side business, Your Agent Guide. It's a real estate agent referring organization. I am a licensed real estate agent in Washington State. I did that so that I can help people find good agents in their areas to be connected, have a better understanding of the law of real estate in Washington. There are a lot of really crummy real estate agents out there, and either that they're after your commission and they don't care about you, or that they're just not skilled and make a lot of mistakes. And so I started this just to help people find good agents.
Well, like we've talked about before, it is more about having a relationship with somebody, and you build that relationship and you trust them more and things like that. I think the idea of scrolling through Google to find an agent in your area, that could work. It's probably very difficult. You probably have to do a lot of phone calls, a lot of back and forth, a lot of meets. At least this way you're out on YouTube. I've asked, you're doing more video stuff, right?
I will be. Okay. I'm starting to come up with a list of videos that I want to do stuff on.
The audio listeners, he's pointing to a whiteboard next to him that I can't see, which is good. But I want to see your secrets, man. I want to see.
And the YouTube video's intention is just to sort of educate people again on how do I choose a real estate agent. I offer the service to help connect people, and I charge a referral fee to the real estate agent when I make those connections. That's how I get paid in this process. So it's a zero cost thing. Mm-hmm. But the important part is getting people connected with agents that they resonate with. There's every single agent that is worth their weight in salt and doing representing people in real estate is going to tell you that they're the greatest agent in their market or like number one sales, and there's all this marketing around it. And to be honest, like there's a ton of really great agents that don't want to be number one because they want to focus on their individual clients. So for me, as we've talked about, it's more about having a good relationship, good, clear understanding and communication with the agent you're working with, and someone who actually understands how the processes work and is taking care of their client's best interest.
Yeah.
As a
Again,
licensed
it's a
agent.
relationship, and that's how it should work. You get a good relationship.
Exactly how it should work. I mean, I remember the story when you bought your house.
Yeah, it was kind of cool, and I think because it was so cheap, they weren't getting a lot. So it was like, well, what's the point? We have 3 other people we're dealing with where we can get a much bigger commission. I'm glad he got a house, but stuff like that. Yeah. So
I mean, both your agent and your loan officer for your mortgage were both kind of like questionably.
They were married, which I don't know if that is I don't know if that's like a conflict of.
There is no conflict of interest in that, but I mean, it does kind of explain why both of them were a bit kind of shady in their approach to things. Not illegal by any means, but in my own personal opinion,
they seemed really nice and everything, but there was a slickness to both of them because they'd done it so much. Where you're
it really felt like they were really trying to push you into a decision that you needed to make and not them.
Yeah, I mean, there's a difference between being confident and being pushy. you know.
Anyway, we can go on this conversation. The whole thing is,
We'll
check
do
it
real
out.
estate.
Your
We'll
Agent
do an
Guide.
episode on real estate.
YourAgentGuide.com is my website. You can find me on YouTube on Your Agent Guide. Right there is one video at the moment, but there will be more coming shortly. And of course, Your Agent Guide on Facebook and Instagram.
Cool. Yeah. So for me, just this obviously, and my other podcast, Game with Grief. If you like video games and movies and stuff like that, I talk about them over there. In fact, the episode that is out now but will be on the website tomorrow is when Avin beat me at Age of Empires 4. So if you want to hear about a 35-minute... that's thumbs up for Avin. If you want to hear a 35-minute talk of Avin just smoking me in Age of Empires 4 twice... I mean, I don't even know. He probably should have, not even
shouldn't be braggadocious in any way, shape, or form. Joe does not play this type of strategy game and doesn't have a lot of skill at it. And so, you practiced it, 3 or 4 games before we played, and it was the first time you'd played a strategy game like this in 10 years or more?
Well, again, like I said in that episode, I knew it was screwed when I called you a month out and was like, hey, we should do this. How are you liking the game? And it was a 30-minute tear on, I like this, and I got this strategy, and I was like, man, I'm so, I'm just, at that moment, it's over. But yeah, go there. That's www.gamingwithgrief.com. Subscribe to the podcast. It's the same name, Gaming with Grief. It comes out every week, even though this one comes out every month. And I think with that, we will leave you guys, and we'll see you next month.
Okay, thanks again, everybody.